Welcome to Ground Rules, Employment Law Over Your Coffee Break. My name's Pam Howland, and I'm here today with Doug Plass and Jennifer Walrath, and we are talking about national origin discrimination. This is a hot topic right off the press, basically, in the sense that we have seen developments and evolutions in 2025 with the EEOC in regard to how they view national origin discrimination. We know that in 2025, the EEOC chair, Andrea Lucas, has indicated that prioritizing American workers from anti-American bias has been a priority of the EEOC and will continue to be so. We've seen some executive orders indicating that the EEOC is trying to move in that direction. And most recently, in mid-November, we saw an EEOC technical assistance bulletin come out that we want you to be aware of and that we want to talk about a little bit more today, because it really is different than the way we have traditionally viewed concepts related to national origin discrimination. And it's important for employers to know that this is out there and to be making decisions that don't run afoul of this, or to at least be making educated decisions full well knowing that this is how the EEOC is viewing national origin discrimination. So as you look at this technical assistance bulletin, it says, what can anti-American national origin discrimination look like? And then it gives several examples. And we kind of want to talk through those a little bit. So Jennifer, Doug, anyone kind of want to jump in and talk about what was noteworthy to you in this EEOC technical assistance bulletin?
Well, I guess there's a lot of interest to me, and I guess I'll back up a little bit. You know, when Andrea Lucas announced, a focus on anti-American bias back in February, I don't think anyone really knew quite what that meant or what it looked like, right? And it was kind of a mind bender, right? To think about, we are in the United States, how would, American companies and businesses be discriminated against American workers, right? It's kind of a strange concept to a lot of us. And I think what this, to me, indicates is the focus is really on industries that rely heavily on like H-1B visa holders, have a lot of that in their workforce, maybe have migrant workers, and even, migrant workers that are like legal right here in the U.S., not necessarily illegal immigrant, but maybe you use some of the agricultural migrant programs that exist. If that's something that you do, then that is at least among the things that we are talking about here. Although it isn't necessarily the only thing. And quite literally, before we sat down this morning, I went and looked at the recent EEOC press releases, and the 25th, so just a few days ago, but basically right before Thanksgiving holiday, there was an announcement of a settlement that the EEOC had reached with a farming operation in Mississippi. And in that case, it was an operation that hired immigrant agricultural workers to supplement its existing workforce. And the existing workforce primarily was Black farm workers of American national origin. So that isn't an employer who's using, H-1Bs. It's not an employer who is necessarily taking advantage of a migrant worker program, right? So it's just an employer who has a diverse workforce, essentially, right? And the EEOC alleged that the company, this farming operation, had discriminated against its Black American farm workers by providing the foreign immigrant workforce with preferential job assignments that were less strenuous, that had more work hours, higher pay, and higher bonuses. So it's a little bit interesting because, there's not a lot of details in the press release, but that actually suggests that the immigrant workforce was getting paid more because they were working more. What we don't know is whether or not the same opportunity to work more was offered to everyone equally, right? There could be some facts there that are behind this case that we don't know about. But in that instance, they said, look, you were preferring the immigrant workforce in their compensation and in how you gave out work assignments, and the farming operation ended up settling for $150,000 and entered into a 3-year consent decree, which for employers to have a multi-year consent decree is kind of a big deal. So, I guess all to say, I think even if you aren't an employer who has maybe like H-1Bs, you still could be needing to be concerned about this just because of the dynamics in your workplace. And I think for people in industries like agriculture, where maybe it's historically been difficult to find labor, this is going to be tricky. So I guess that's one of my big takeaways is, I think if you're someone in those spaces, what do you do? And this could be difficult for you to comply because you might be listening to us talking here and say, well, then who in the heck do I hire? What do I do? How do I find people to work for me?
Yeah. And that case you just brought up, I mean, it's kind of the opposite of how we've been thinking about these things, right? So I'm thinking about this in terms of, this technical assistance bulletin talks about HB1 visas and foreign workers coming in on these visas. And we think about that as, okay, these visas were set up in order to allow American businesses to hire foreign workers because there aren't American workers available to do those jobs, I guess, at those rates, probably.
And in fact, real quick, for an H-1B, we're not immigrant lawyers, but immigration lawyers, but as I understand it, you do have to show that there's not an American worker being displaced to even get the visa.
To even get the visa to begin with. But I think what this is saying to me is that you have these people lined up that have this visa. You can't just go out and say, okay, I'm going to hire some H-1B visa holders from some particular foreign country. You, at the very least, have to offer those positions to American workers. And it's a little unclear to me beyond that what you have to do. Because like we were talking about beforehand, this is all couched in terms of disparate treatment, whether or not there's some disparate impact concepts floating around here as well as to, even if you're doing things neutrally, do you really have to ensure that American workers and foreign workers receive the same terms of conditions of employment in all states? I don't know. I don't know.
Yeah. So that case that Jennifer was talking about, I mean, that really sounded like something that Idaho employers could have some parallels with, whether it's dairy, whether it's ag. We've got parts of the state that definitely use migrant employees. And if you're listening to this going, geez, that's something we do, then you should pay attention to this technical assistance bulletin for sure. And it gives a few examples of things that are prohibited. One bullet on there talks about discriminatory job advertisements. It says evidence of discriminatory job ads can include ads that say the employer prefers or requires applicants from a particular country or with a particular visa status. That's one thing they're looking at. So discriminatory job advertisements. Doug was just talking about disparate impact versus disparate treatment. It has a bullet on there that says disparate treatment could be related to a company terminating American workers who were on the bench between job assignments at a much higher rate than employees who were visa guest workers. And we're like, that's kind of an odd phrase, that on the bench. Jennifer, Jennifer did a little digging and got an understanding of what that is referring to, the on the bench reference.
Yes, at least I think that I did. I guess I can't say for certain what the EEOC meant, but there is a case here in the Ninth Circuit, actually, that used the same term in describing the facts of what was going on in that case. And in that case, it was a project-based employer where, maybe they would staff out teams and the teams would change once a project was done. And for those people who were not actively assigned to a project and working on a project, they were considered to be, riding or sitting on the bench. So they're still, hired and employed, but they're not assigned to work on a team on a project at a particular time. And in that instance, that employer, if someone had been sitting on the bench for 5 weeks, I believe, they were automatically terminated. And so essentially, if you're an idle worker not actively being assigned to a project, you would be terminated. And in that case, the allegation was that the percentage of people being terminated automatically under that program were predominantly American workers and not H-1B visa holders or guest workers of some kind. So that's what that seems to suggest, is if you're, and I was thinking about this too, even with, hourly workers, right? Like if you have hourly workers who are just willing to take all the overtime, for example, whereas other people might say, you know what, no thanks, I'm good. Do you as an employer kind of have to do more to ensure that there's at least equal opportunity for those hours, right? Like maybe some workers might say, well, Bob hasn't wanted overtime for a year, so let's just keep offering it to Joe. You never ask Bob anymore if he wants overtime. You just always ask Joe and give it to Joe. So Joe ends up working more hours, but he also gets paid overtime, so his compensation is higher. Turns out Bob's an American worker, and maybe Joe is a non-American worker. So do you end up with a claim in that circumstance? Unclear, but maybe in this situation. So all to say, I guess, reasons to kind of think a little bit more about how you hand out work. What are your protocols for work assignments, how you offer things like opportunities to work overtime, right? And are you doing it in a way that is, kind of fair and uniform to everybody and isn't, whether intentional or not, right, preferring persons of certain backgrounds and national origins?
Yeah. So another area that would fall under what's prohibited under this national origin discrimination bulletin is evidence of hiring practices that make it more difficult for applicants from one national origin to apply for positions. It says, for example, subjecting U.S. workers to more laborious application methods than H-1B visa holders. That would be an example. So then in addition to that, you have harassment based on national origin. That's nothing new, but now we're talking about harassment against Americans in the workforce. And an example came to my mind of a case we had a few years ago involving a large manufacturer that had a lot of employees from other countries. And there was an American there in particular saying, there's a large group of Hispanic employees and they've made me feel uncomfortable because they're constantly telling that I'm lazy and I don't work as hard as they do. I think there was a time when employers might discount complaints like that, thinking, well, it's an American, they're in the majority class. Is that really harassment? According to this, it is. So, if you've got an outdated perspective or view on what harassment or discrimination looks like, time to freshen that up a bit in light of this bulletin and in light of some case law that we've seen recently. We were noodling through this before the podcast started and thinking through that Ames v. Ohio United States Supreme Court case from last summer that was talking about whether or not it's harder for people in a majority class, like say white male Americans, is there a heightened standard for them to prove discrimination? Ames involved, if you remember that one, that's the one that involved the straight woman from American woman who was claiming she was being discriminated against because some LGBTQ employees had been promoted ahead of her for positions. And in that case, the United States Supreme Court last summer said there is no heightened standard, whether you're in a majority group or not. Title VII prohibits discrimination in all scenarios. Everyone should be treated equally. So applying that to what we're talking about right now, the white male example of someone saying that they're being harassed in the workplace by people, employees from other countries, that would be discrimination or harassment under this technical bulletin. So maybe time to rethink your views on what harassment or discrimination looks like. Jen, Doug, do you guys have any other thoughts on that?
Yeah, I mean, I think it's really, we talk about this stuff and it's really important, when we talk about like the disparate treatment, it's anytime you're taking somebody's protected class status and saying, this person is X, we're going to do Y. Don't do any of that, right? That's the problem. The problem isn't that these people that are sitting on the bench, these American workers aren't getting pulled at the same rate as somebody else if you have a good reason for doing that. This is just first level evidence of discrimination. This is going to get somebody into a courtroom, which is, for us, the game is kind of lost once you get there. But the reality is employers are going to be in all sorts of situations with all sorts of employees, with all sorts of different protected class statuses. And as long as you're using metrics that don't have anything to do with those protected classes to make your decisions, you're still going to be okay.
Yeah, and I agree with Doug 100%. I think what we were talking about before the podcast started is, what do you do if some of your metrics you've classically used might dovetail with the protected class status, sure, right? So that's, I think, in this instance is the rub. And I guess in my mind, this really has more to do with the hiring side of things. For what Doug was saying, once people are in your workforce and you are monitoring performance, making decisions about management, definitely makes it much more important than ever before. And we talk about this all the time, to timely document issues. If someone's not meeting performance metrics, if someone is having conduct issues, violating policies, right? Because those are all going to be the kinds of things Doug's talking about, right? Like good, legitimate reasons why I'm making the decisions that I'm making regarding my workforce. The national origin one, I think where the especially tricky bit is the hiring. And we were talking about this, is like cost of labor, right? If you have... kind of circling back to what Doug was saying at the top of the podcast, that, we have these programs here in the U.S. that have essentially allowed American employers to bring in workforces using these programs, like migrant worker programs and H-1Bs. If that was part of your model for how you operate your business to save money, maybe, engage in a particular industry at a lower cost, is that still valid? And I will say that this EEOC one-pager says very explicitly, the following considerations do not excuse an employer's decision to hire foreign workers over American workers. And there are three things listed. One is customer-client preference. One is beliefs that workers from one or more national origin group are, quote, more productive or have a better work ethic. And the other one is lower cost of labor. So I don't know that we're going to answer all the questions today, but I think that definitely is probably a big question for certain employers if you are pretty reliant on those types of programs for a workforce. Or if asked, you would say, well, I hire those people to save money, right? That's why I do what I do. This is calling into question whether or not that is a valid way to operate under Title VII. Now, I think we'll see how this plays out long term. But, if you are an employer in that space, it might be a good time to at least focus on this, take a look at it, do a little legwork on this, because this document, again, 1 page from the EEOC, suggests that, you may have to.
And what I thought was really interesting about that lower cost of labor is the parenthetical next to it, which says, whether due to under the table payment or abuse of certain visa holder wage requirement rules. So that suggests to me that you're doing something wrong in the lower cost of labor. Now, maybe we'll come to find out that some of those visa program requirement rules are themselves illegal. But for now, I think as long as you're, doing things correctly, you're going to be in better shape at any rate.
Yeah, that's interesting. That jumped out at me too, because I was surprised to see the language that says the following considerations do not excuse, in bright red letters, an employer's decision to hire foreign workers over American workers, and that lower cost of labor piece. Because we always talk in terms of, Doug talked about this a little bit earlier, having a legitimate non-discriminatory reason. Lower cost of labor would be, theoretically, in many scenarios, a legitimate non-discriminatory reason for taking an action. So is that what the EEOC is contemplating? Like, anytime you're going to argue lower cost of labor, that does not justify the decision to hire someone from outside of the U.S. over an American worker? We don't know. But that language where they say lower cost of labor, parens, whether due to under the table payment, that jumped out at me. I'm like, well, of course, if it's illegal, like if you're not paying taxes and you're paying someone under the table, you're not going to be able to say, well, it was more economically feasible for me because I'm paying them under the table. That's not going to fly. But yeah, theoretically, if it's a lower cost of labor, but you're complying with the law and doing everything you need to, is that going to be a legitimate non-discriminatory reason? Hopefully. I mean, we just don't know yet. Like, this is, like we said, we're a couple weeks at best in from this guidance. We don't have really court cases. I mean, Jennifer was citing to a couple of cases that are...
Although, interestingly, I mean, this is a little bit in the legal weeds, they weren't Title VII cases. Oh, yeah. The basis for the claims was something else. But the underlying facts of the cases that I had, kind of peeked at had a lot of parallels to the types of things that are in this guidance.
Yeah. Yeah, remember that this is EEOC guidance. And courts don't necessarily, it's kind of its own complex issue, like the extent to which a court gives deference to EEOC guidance, but courts don't necessarily have to look at this and say, I agree, that's what I'm doing. There's a whole test that relates to the extent to which a court needs to do that. So who knows? I mean, maybe some of these issues will land in front of a court that says, no, I don't agree with this. But for now, I mean, we do pay attention to EEOC bulletins, to guidance, because if you have a complaint brought against you, it's going to land in front of either the Idaho Human Rights Commission here or the EEOC, and you're going to want to know what the ground rules are for that, for sure. So, haha, everyone liked my reference to the word ground rules, to that phrase. Yeah. Yeah. So anyway, pay attention to this. I'm sure undoubtedly we'll be seeing more on this as 2025 winds up and into 2026. And, takeaways in the meantime, if someone comes to you, an American employee, and says, I think I've been discriminated against, and gives you something that might fall within this bulletin, pay attention. Treat it like you would any other complaint. Don't discount it because it's coming from someone who you typically would think of as being in a majority class. So I would say that's the big takeaway on this one for me. You guys have anything else that jumps out at you?
I think if you have a workforce that in any way is made up of maybe migrant workers, non-U.S. workers, visa holders, pay attention. Take a look at this. Per our discussion, maybe the way you're operating and doing things is going to be perfectly fine. But I think it's worth taking a look, looking at these guardrails, and then also, I think what's interesting is in some ways, for a long time, we've not thought about immigration law and employment law being all that related, and that is sort of changing a little bit. So you're going to want to make sure that you are complying with, both areas of the law, right? That, just because you've gone through and checked all the boxes on the immigration side, you may also need to just double check that how you're operating, what you're doing, especially with hiring, is also checking the boxes and compliant on the Title VII EEOC side.
Yeah, and I would just also say, if you have any assumptions as to whether what American workers will or will not do, throw those away. just forget about these assumptions. Forget about how you've done it in the past, and make sure that you're offering these positions to anyone who is available to take them.
Yeah, that's always good advice. I mean, operating on stereotypes or assumptions is going to get you in trouble under any of our federal and state anti-discrimination laws. Okay, stay tuned for more. We'll keep you updated as we learn more, but that's it for today on Ground Rules.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.